open this particular session. This happens to be the in the last phase of the International Teaching Month. So this session is on the topic corporate personality. And in this session, we have Professor Lindsay Trotman from Massey University. So let me give a brief introduction of Professor. Professor Lindsay Trotman is Associate Professor with Massey University, New Zealand. Sir is associated with School of Accountancy. Sir has contributed a number of company law publications in New Zealand and Australia, including company and company securities law. Sir has written several books and is also the editor of Australian Journal on Competition and Consumer Law. Apart from being associate professor, Professor Lindsay is also a barrister and solicitor of the High Court of New Zealand. He is honorary solicitor for a number of charitable, trust and incorporated societies and is engaged in numerous university and community activities. Sir has interest in company law, particularly in misleading or deceptive conduct. Sir has contributed a lot for academics in the form of paper publications, books, and in the form of conference proceedings. So I hereby welcome sir, and I request our director Puri Pokhrial ma'am to introduce sir. Welcome sir formally.
Sir, ma'am has not been able to rejoin yet, I think.
Okay. So let me proceed with.
It says it's taking time, so maybe we can begin the session and then.
Yeah. So before I call up sir to talk on this session, let me give a brief introduction to the topic. So today's topic is corporate personality. So this is for the students as well as to our sir Lindsay Trotman, that in Indian, as per the Indian company law, we do recognize the concept of corporate personality, and we also recognize that the concept of corporate personality is backed by various theories. So here, the purpose of recognizing this particular corporate personality is because of the pros which it has. It gives us the legal personality, perpetual succession, then the company can sue and can be sued, and it provides unlimited liability. Whereas the concept of corporate personality is also limited by in certain situations. In situations where the members of the company try to do some illegal activities or try to avoid the liabilities, then the courts in India never hesitate to lift the corporate veil. So the structure in India is that we do recognize the corporate personality and a separation of the juristic person and the members of the company, but we never hesitate to lift the corporate veil in the events of fraud or any similar activities. With this introduction to the concept, I here now invite Professor Lindsay.
Thank you very much for your kind invitation. And welcome to all of those who are in the room and listening. I understand that you've all studied jurisprudence and that some of you have studied company law. So that's a good start and hopefully will assist you to understand what I've got to say this afternoon. So I begin with the question, what is corporate personality? I just want to set the scene a little here. It is, of course, recognition of a company as a legal person, meaning, as you've just heard from the introduction, that the company has rights and has duties. So it's the idea of legal personhood applying to a corporation or to a company that has been incorporated. That's what it is. And this, the company is a different legal person to every other person in the world, including, of course, the shareholders, the directors, and anybody else associated with the company. All right, if the company is a legal person, then it's a person in the eyes of the law, separate and distinct from every other person in the world. It also means, of course, that a company is not an item of property, because you can't be both. You can't be an item of property and be a legal person. It's one or the other. So that's what corporate personality is. And the next question that I want to put to you is, well, why is a company a legal person? Why is a company recognized as a person, just like you and I are recognized as legal persons? Well, the answer to this question is that it's the effect of incorporation. Right? To bring a company into existence, it's necessary to engage in an incorporation process, or what is sometimes described as a registration process. All right? And it's the effect of that incorporation process that bestows on a company its legal personhood. So if it's the effect of incorporation, I just want to explore some words a little bit to help us understand why it's the effect of incorporation. Here is a definition of the word incorporate: to establish as a corporation. That's what we do when we incorporate. We establish a corporation, which of course begs the question, well, what is a corporation? The word corporation comes from Latin, all right? And I reproduce here a couple of Latin words: corporere, all right, which translates form into a body. That's what corporere means, form into a body. So the whole idea of incorporating something is to form a body, and that body becomes the legal person, separate and distinct from all others associated. All right. You may be familiar with the word corpse, of course, and the word corpus really means body. So when we go through an incorporation process, we are forming a new body, and that body has legal personhood. In India, the effect of the incorporation process, or the effect of registration of a company, is set out succinctly for us in Section 9 of your Companies Act of 2013. Those of you who have studied company law will probably be familiar with this section. All right, and this is what Section 9 tells us. Its heading is the effect of registration, and it tells us from the date of incorporation, right? So that we know that we've incorporated something once we've gone through this registration process. From the date of incorporation, subscribers to the memorandum, that's your initial shareholders, and anybody else who comes along later and becomes a member of the company. Look at these words in bold: shall be a body corporate. All right. Here's this separate person that's been brought into existence. All right. Shall be a body corporate. So this is the initial subscribers and anybody who joins them later. They shall be a body corporate by the name contained in the Memorandum of Association. And look at this: is capable of exercising all the functions of an incorporated company, and having perpetual succession, the power to acquire, hold, and dispose of property, to contract, and to sue and be sued. Of course, it follows that a legal person, if a legal person is something that can have rights and duties, so it follows that they've got to be able to sue and be sued in order to enforce their rights and to have their duties or obligations enforced against them. So this is the provision in the Companies Act 2013, your Companies Act, that means that a company is a legal person. We've got the statute telling us that once you've been through the registration process, you have brought into existence a body corporate. All right, so you've formed this body, and that could just as easily read shall be a legal person, because a body corporate is recognized by the law as a legal person. Now, I want to take you now to a much earlier statutory provision, and this is section 18 of the Companies Act of 1862 of the United Kingdom Parliament. All right, so this is an act of the UK Parliament, Companies Act 1862. But I want you to note the similarity between this provision and your section 9 that we've just had a look at. Basically, your section 9 is a direct descendant of this section 18. And again, we get, look at the words that I've put in bold. That's my emphasis. All right, the company is incorporated. We've got a body corporate as a result of the registration process, and reference to an incorporated company, the separate body or legal person that results from going through the registration process. Now, why am I showing you section 18 of the UK Act of 1862? Two reasons. The first I've already mentioned, because that's where you got your current section 9 from. And the second reason is that this was the section that was interpreted by the House of Lords in Seamen against Seamen and Company Limited. Now, I don't know whether you've visited Seamen in jurisprudence, but you'll surely have visited Seamen in company law, those of you who have studied company law. And in the House of Lords, the law lords interpreted section 18. They looked at this section and said, well, what do these words mean? And of course, the Seamen decision is regarded as the case that put beyond any doubt the meaning of these words. Here I have a quote from just one of the law lords, Lord McNaughton, where he's referring to those words in section 18, and he's saying those are strong words. The company is at law a different person altogether from the subscribers. All right, so that's my emphasis, the italics. He's saying that as a result of section 18, your current section 9, the company is at law a different person altogether from the subscribers. All right, so we've got a separate person here. The company in its own right is a person separate altogether from the subscribers. That's enough on what corporate personality is. All right. Now, in the introduction, Professor Shinde mentioned that there are some limits to this principle. And I just jotted down that he noted that the courts in India never hesitate to lift the veil if there is fraud or similar activities, were some of the words that he said. So let's now, and I want to spend the rest of the session on the concept of lifting the veil, as it's called. Now, that begs the question, of course, well, what is the corporate veil? I haven't mentioned this previously. I talked about the principle of corporate personality. But the veil is simply a metaphor used to describe the legal personhood of the company. That's all it is. It's the principle of corporate personality. All right, that's what is meant by the corporate veil. So presented diagrammatically, it might look something like this. All right, if you can imagine that those two lines represent a veil over something, and I put underneath the, so I'm suggesting to you, this is my veil, all right? And underneath it are shareholders, directors, other persons associated with the company, all right? So it's said that the principle of corporate personality that I've just been talking about is supposed to cast a veil over these people. And the veil, if you like, represents the persona of the company. The legal person resulting from incorporation is represented by this veil. That's what I mean. It's just a metaphor for the idea that the company is a legal person. So what is lifting the veil? Well, to continue with the metaphor, all right, lifting the veil is when you, if you like, get hold of it and lift it up and cast it aside, toss it away. All right. And when we do that, we no longer recognize the existence of the corporation as a legal person. So its legal personhood, if you like, is destroyed. All right. So this is the way that Lord Sumption put it in the UK Supreme Court in Prest, and that's a case I want to come back to in this session. All right. He says lifting a veil means disregarding the separate personality of the company. All right. So when we lift the veil, we ignore what Section 9 of your Act says. We do not recognize the registered company as a legal person, right? Because we disregard its legal personality. So that's what it is. That's what is meant by lifting a veil. You know, I put the question to you, well, who does this? Well, essentially, there are two institutions that do it. One is Parliament and the other is the courts. All right. And I want to focus on veil lifting by the courts. All right. But it is, of course, open to Parliament to pass a statutory provision, the effect of which is to produce an outcome that ignores the corporate personality or the legal personhood of a company. But let us concentrate not on Parliament doing it, but by the courts doing it, and the courts doing it without legislative sanction. By that I mean the courts doing this without any permission to do so from a statute, without any discretion vested in them by a statutory provision. In other words, they are relying on judicial powers to do this. They're relying on what might be described as a common law power to disregard the legal personhood of a company that's been through the incorporation process and by reason of that obtained legal personhood. So I put the question to us, well, when does this happen? When will the courts do that? And I suggest to you here that the answer is different in different jurisdictions. And my plan this morning, your time, is to have a look at 3 different jurisdictions: New Zealand, the United Kingdom, and India. All right. So if I may start with the position in New Zealand, and this is something that you probably don't know about, even if you have studied company law. But here in New Zealand, there's a statement of principle that was articulated way back in the 1970s, in 1978, by our Court of Appeal, by the New Zealand Court of Appeal, in a case called Re Security Bank Limited. All right. Now, in this case, the Court of Appeal said that we must adhere to Seamen. In other words, we must leave the veil in place unless these words in bold apply. All right. Unless leaving it in place would lead to a result so unsatisfactory as to warrant some departure from the normal rule. All right. So only if leaving the veil in place would produce that sort of result, according to this principle, can the veil be lifted. And before that, look at this caution here. All right. Here's Richmond P, that's the president of the New Zealand Court of Appeal, saying the starting point, we must always start with the importance of Seamen. That was re-emphasised in Lee. Lee, of course, you may be familiar with, Lee and Lee's Farming Limited. That's a New Zealand case that went to the Privy Council in London, and a contribution from New Zealand to the concept of corporate personality. And look at this, any departure from Seamen or Lee is to be watched very carefully. So this is a caution, a warning. And in New Zealand, we take very seriously any departure from the principle of corporate personality. We do not lift the veil lightly in this country, all right? And since 1978, our cases have all followed this statement of principle, which is a broad statement, all right? That's a rather broad statement, leave the veil in place, unless it would lead to a result so unsatisfactory as to warrant departure from the normal rule. So it does give the courts some freedom because it's a broad statement, not a narrow statement. And what's happened is this statement has been applied pretty consistently, or consistently in all later cases. All right. It may be that we're about to see a change in New Zealand, but at the moment, this is still the guiding principle. I'll just come back to that later about the possibility of change. Now, I want to take one case from each jurisdiction to illustrate. All right. So obviously, I want to take a New Zealand case to illustrate the application of this statement of principle. And so this is the case that I want to illustrate. That's that guiding principle. New Zealand Seamen's Union against the Shipping Corporation of New Zealand. All right. Now, it involved the New Zealand Seamen's Union, and other unions, in fact, and an industrial award between that union and the Shipping Corporation of New Zealand. What do I mean by an industrial award? I mean an agreement, all right? A negotiated agreement, a consensual arrangement between these parties. And the agreement was as to the terms and conditions on which officers and crews on ships would be employed. All right, the Shipping Corporation of New Zealand, that was a shipping operation, and it owned ships, of course, and it employed officers and crews to staff those ships. So there was this agreed position between the unions and the employer as to the terms and conditions on which officers and crews would be employed. Now, the Shipping Corporation, for reasons which I don't need to go into, wanted to have a change to those negotiated and agreed terms and conditions because they were not internationally competitive, all right? On a comparative international basis, they were very much in favour of the officers and crews, or if you like, of the employees, compared to terms and conditions on which officers and crews were employed throughout the rest of the world. And this meant that the Shipping Corporation of New Zealand was unattractive as a buying proposition on the international shipping market. And that's what the Shipping Corporation wanted to do. It was preparing itself for sale on the international market. So it entered into negotiations with the Shipping Corporation. The corporation entered into discussions with the unions with a view to trying to change these. And those discussions continued for some time, 9 months, in fact, without much progress. Obviously, the unions were reluctant to concede the conditions that they had previously negotiated. So the Shipping Corporation became rather frustrated. So it engaged in a plan, if you like, or implemented a plan the object of getting away from the terms and conditions in the industrial award. All right, so here is the plan. Okay, basically the shipping corporation acquired 2 Hong Kong registered companies. All right, but these companies became wholly owned subsidiaries of the shipping corporation. All right, they became wholly owned subsidiaries. So they were controlled effectively by the Shipping Corporation of New Zealand. Then it transferred a ship to each of these companies. All right, so, and then the ships were reflagged under the Hong Kong flag. They'd previously been flagged under the New Zealand flag. And having transferred ownership of the ships to these Hong Kong registered companies, all right, the officers and crews on each of those ships were then dismissed, and new officers and crews were employed on completely different terms and conditions to what were set out in the industrial award. Now, there is a connection with India here. One of the reasons why I chose this case, because on one of these ships, the new officers and crews were Indian. All right, so the ships were sent. They were sent to international ports. They were out of New Zealand waters. They were sent to international ports. On arrival, everybody got dismissed, and new crews appointed in their place. Now, of course, when the union objected, the response of the shipping corporation was, well, yes, we're bound by the industrial award, but we don't own these ships anymore. We don't employ the crews on them. We've transferred them, we've sold them. And of course, all of this relied on the principle of corporate personality. The idea that the 2 Hong Kong incorporated companies are completely different persons to the shipping corporation. And it doesn't matter who owns the shares and therefore who controls, just as it didn't matter that Mr. Salomon owned most of the shares in Salomon and Company Limited and controlled Salomon and Company Limited. So, yeah, at law, the corporation is saying, we don't own these ships anymore. We don't employ the staff on them. And so go away, basically the corporation's saying to the unions. Well, the issue, the unions took proceedings, as you can see from the identification of the parties here, and it asked the court to ignore the separate personality of the 2 Hong Kong companies and to effectively say that there's really only one company here, and that's the shipping corporation, or really only one person, if you like, not 3, and that the effective owner of the ships and the effective employer is really the Shipping Corporation of New Zealand. But for that argument to succeed, all right, the court had to disregard the separate legal personhood of the 2 Hong Kong companies. If that legal personhood is disregarded, then you can no longer say that they are the employers or the owners of the ships, because if the person's not, if the legal personhood is destroyed, then there's nothing left to own or to act as an employer. The judge found on the evidence that the sole purpose of the reflagging exercise, the sole purpose of the whole plan, if you like, was to break out of the New Zealand awards. And there was even evidence that showed that the Shipping Corporation would reverse everything. In other words, bring the ships back under the New Zealand flag, and so on, just reverse the whole plan if the Seamen's Union, if the unions would accept different terms and conditions to those that were set out in the previously negotiated industrial award. So the issue became, well, was the principle that was articulated in Security Bank, was it satisfied? All right. If the veil was left in place on these two Hong Kong companies, would that lead to a result so unsatisfactory that departure from the normal rule was justified? The normal rule being, of course, that they're separate persons to this person. That was the question for the court. And of course, if you left the veil in place, the result was that the shipping corporation had successfully avoided the industrial award. That would be the result. So this is what the judge thought. He refers to Security Bank, all right, but he reached the conclusion that the veil should be lifted. And his view that to leave the veil in place on these facts would lead to a result so unsatisfactory that there had to be some departure from the normal rule. Okay, that's enough on the New Zealand position. Let me take you now, because I'm conscious of the time, let me take you to the UK position. I'm not sure if those of you who have studied company law will be familiar with Prest and Prest. This has to be regarded as the leading UK case. It's a decision of the UK Supreme Court issued in 2013, and it's been followed ever since. All right, so I've endeavoured here to present the facts, but just let me say at the outset, though, we're going to see that the position in the UK is much stricter than in New Zealand. All right, so here's the facts. Mrs. Prest was the beneficiary of a matrimonial property award in the family court, all right, following a divorce. All right, Mr. and Mrs. Prest were married for some years, the marriage broke down, they were divorced, and there was a matrimonial property division, and the family court had been involved, and it had ordered in favour of Mrs. Prest an award of money. That award wasn't satisfied, wasn't met by Mr. Prest. So the proceedings that involved the principle of corporate personality were an application by Mrs. Prest for ancillary relief following this lump sum award. And what she asked the court to do was to make an order transferring property owned by some companies to her to help satisfy this award in her favour here. All right. So she's saying, please make an order, a court order, transferring some properties that are owned by some companies. Now, these companies were all controlled by Mr. Prest. All right, so they're under Mr. Prest's control. All right, but the ownership of the property, of course, is vested in the name of each of the companies involved. So the problem she faces, of course, is that this award here isn't against the companies. The award she had in the family court was against Mr. Prest. And we know from Seamen, section 9 of your statute, that these are all separate persons to Mr. Prest, notwithstanding his control of them. So as Lord Sumption succinctly identified the issue here, the question is whether the court has power to order the transfer of the 7 properties to the wife, given that they legally belong not to Mr. Prest, but to the companies. So that's the issue that the court had to grapple with. And in grappling with that issue, Lord Sumption undertook a very comprehensive review of the law relating to lifting the veil. And he came to a conclusion, all right, and his conclusion was, based on his review of all of the previous cases, that there's a very limited principle of English law which allows the veil to be lifted. All right, here's his conclusion. It's been called the evasion principle. This is at paragraph 35 of his judgment. I conclude that there is a limited principle of English law. Limited, the emphasis is mine. And this applies, he says, when a person is under an existing legal obligation or liability. Right? So it only applies when somebody's under an existing legal obligation or liability, or subject to an existing legal restriction, such as a prohibition, not a prohibition, for example, okay, which he deliberately evades, or whose enforcement he deliberately frustrates by interposing a company under his control. All right, so you've got to have an existing legal obligation or liability, or an existing legal restriction. And then the person who's under that liability or restriction must then evade or frustrate the enforcement of that existing obligation by interposing a company, putting a company between him and the party to whom the liability is, for example, or the party to whom the obligation is owed. All right, so he's the limited principle that he terms it. That's when it applies, only in those circumstances. And he then went on to say that in those circumstances, the court may then pierce the corporate veil. That's another term for lifting, of course. And only for the purpose of depriving a company or its controller of the advantage that they would otherwise have obtained by the company's separate legal personality. Right, so he's saying the only time that the court can pierce the corporate veil is in those circumstances that he had just identified there. All right. If you can't bring the facts essentially within that limited principle, then the veil cannot be lifted. All right, that is his summation of the law on piercing or lifting the corporate veil. So then, of course, it became a question of, well, was the evasion principle satisfied on the facts? And the answer is no, it wasn't. All right, because there was no evidence that Mr. Prest had interposed the companies in order to frustrate or in order to evade an existing legal obligation to his wife. All right, they'd been the properties had been acquired by the companies before any breakdown of the marriage. And the reasons were, as is noted in this statement here, wealth protection and the avoidance of tax, quite a common use of the principle of corporate personality. So it followed that the veil could not be lifted on these facts. The order that Mrs. Prest sought, based on lifting the veil, could not be granted. The court refused to lift the veil because that limited evasion principle was not satisfied. Well, what's happened? So remember, Prest is 2013. What's happened since then? Well, the UK courts have adopted this evasion principle and followed it consistently. All right, there's been no attempt to expand that evasion principle as it's become known as. And I just mentioned three cases there to support what I'm saying to you here, that the evasion principle has become the touchstone, if you like, for any attempt to get the veil lifted in England. The latest case that I could find is this last one here, Clipperton against the Commissioners for Her Majesty's Revenue and Customs. That's very recent, 2021. It is only a decision of a tax tribunal, but it's a very clear adoption and application of the evasion principle. These other two cases, and these are not the only three, there are a number of others, but this is a Court of Appeal case, as I note here, and Prasad and Singh was a Privy Council decision on appeal from Trinidad and Tobago. So consistent application of that Prest principle. Let me turn now to India. Now, this may all be old knowledge to you, India, those of you who have studied company law. But correct me if I'm wrong, you company law scholars, but it seems to me that the leading Indian case is this decision of the Supreme Court, your Supreme Court, in 2016. state of Rajasthan against Gotan limestone, Khanji, Udyog. Apologies for my pronunciation. But here I've attempted to present the facts. I wonder if you're familiar with this case. You'll be able to tell me soon. Here's my attempt at showing the facts in some sort of diagrammatic form. There were three partners, all right, three people in partnership. That's what P1 to 3 stands for, all right. And they formed a company. GLKUP Limited was the name of the company, all right. And they became the directors of this company, and they were the only shareholders in this company, all right. So having formed that company, they then transferred to it from the partnership. The partnership had a mining license, and they transferred that for no consideration to this company that they established. Before they did that, they obtained consent from what is referred to as the competent authority. There was regulation requiring the mining license, any transfer of the mining license. If it was to be transferred, consent had to be obtained to the transfer. All right, so the competent authority granted the consent to a transfer from the partners to this company, GLKUP Limited. And it was all on the basis that that these people here, the partners, were desirous of converting their business operation from that of a partnership to that of a company. All right, so that was the basis on which consent was granted. Not too long later, the shareholders, who remember are the three original partners, the shareholders in this new company, all right, transferred their shares to an unrelated company, UTCL. All right, so in other words, UTCL acquires all of the shares in GLKUP Limited, and with the consequence that the partners disappear from being shareholders. And soon after UTCL acquired all the shares, they changed the directors of this company here. And effectively, GLKUP Limited, by that means, became a wholly owned subsidiary of UTCL. All right. Now look at what these partners received when they sold their shares. 160 crore, if that's the correct pronunciation. I don't think you pronounce the S, but I may be wrong. So yeah, so the partners are gone, they're replaced as directors, they're no longer shareholders, and UTCL is very much in control here. So the issue in this case is as I pose over here, was there a transfer of the mining license to UTCL? All right, given that this company is now a wholly owned subsidiary of UTCL. The answer is yes, there'd been no consent given to that transfer, all right, as was required by statute. The requirement for consent was a statutory requirement. So, of course, in law, there's been no transfer of the mining license to UTCL. The only transfer of the mining license was to GLKUP Limited. All right. After that, there's been a transfer of shares in a company, not transfer of the mining license. The mining license is still held by GLKUP Limited. So, how did your Supreme Court deal with this thing? The state said, "Oh well, we've got to lift the veil. We've got to, because if we lift the veil and destroy the separate legal identity, in other words, destroy the legal personhood of GLKUP Limited, who does that leave as the effective holder of the license? It can't be GLKUP Limited because you've destroyed its identity. It's no longer recognised as a legal person." Well, let me take you to the Supreme Court. All right, and first of all, Professor Shinde talked about the courts in India not hesitating to lift the veil. Well, he's right, as we would expect. All right, so here the Supreme Court says the principle of lifting the veil is well recognised. not only to unravel tax evasion, but also where protection of public interest is of paramount importance. So this reference to being able to lift the veil to protect the public interest. That's rather open-ended, it seems to me, because how do you define the public interest? That's extremely broad, I think. And moving on to another statement, all right, from the Supreme Court. The principle of corporate personality is subject to the doctrine of piercing the veil, wherever necessary to give effect to the policy of the law. So I hope you're seeing a completely different attitude in this case to what we, for example, saw in Prest. All right, so here's your Supreme Court saying the veil can be lifted or pierced wherever necessary to give effect to the policy of law. And again here, all right, this reference to the public interest being a basis on which to lift the veil. It is clear that the doctrine of lifting a veil can be invoked if the public interest requires, or if there is violation of law by using the device of corporate entity. So applying these statements of principle, if you like, to the facts, the court proceeded to lift the veil on GLK UP Limited. All right, that company, which remember in law was the holder of the lease as a result of the consented transfer. So here's your Supreme Court saying that that company was formed as a device to avoid the need to get the necessary consent, to avoid the legal requirement for transfer of mining lease and to facilitate private benefit to the parties to the detriment of the public. Again, this idea of the detriment of the public, some sort of detriment to the public interest being a sufficient basis to lift the veil. So by ignoring the legal personality of GLK UP Limited, by lifting the veil on that company, the court was able to say that effectively there's been a transfer to the other company involved, which was, of course, UTCL, and that transfer didn't have the necessary consent, the consent required by statute. Well, what's happened since the Gotan limestone case in India? Well, again, from my research, it seems that the Indian courts have followed the whenever necessary in the public interest approach, as I call it, you know, whenever necessary in the public interest. So, or, you know, without hesitation to refer to Professor Shinde just now. Perhaps let me show you one later case in your Supreme Court to again drive the point home that your approach in India is far more liberal than that, for example, in the UK, and even more liberal than us. Remember, we're in New Zealand very cautious. We've got to show a result that is so unsatisfactory. Here, you've only got to show some detriment to public interest. This is worth. By the way, this is the same Supreme Court justice that wrote the judgment in the Gotan lime case. All right, Justice Gold. So look at what he said. The principle of lifting the veil has to apply when the law is sought to be circumvented. In expanding horizons of modern jurisprudence, it is certainly permissible. All right, he's talking about lifting the veil here. But look at these next words. The bold is my emphasis. Its frontiers are unlimited. He's talking about the frontiers of lifting the veil, the concept of lifting the veil, or the principle of lifting the veil. Unlimited. The horizon of the doctrine is expanding. Protection of public interest being of paramount importance. All right, now all of that, of course, is a huge contrast to Prest, which was a contraction of the concept of lifting a veil, not an expansion, but a contraction, right? A very limited principle, as Lord Sumption described it. So, I mean, there were other judges, of course, in Prest, but they all agreed with the outcome in Prest, and they all agreed that lifting of the veil had to be a very rare matter, very rare. And none of them disagreed specifically with the evasion principle, although some were a bit reluctant to commit to it as the only basis on which the veil would be lifted. But none of those reservations have been latched upon in later cases in the UK. So I would suggest to sort of sum up then, looking at the time, there's clearly differences between the three jurisdictions. We're somewhere in the middle, all right? You're at one end of the spectrum, if you like, and the UK is at the other end. UK being the most restrictive approach, your approach being the most liberal. So I wonder if you might like to consider these questions here. We can come back to these depending on what questions you may have, but I'm looking at the time. So Professor Shindy, would you like me to stop now and we'll take questions and answers? We'll take questions and I'll do my best to answer them.
I suppose, sir, like we have another minute. So you can conclude, sir. Later on, I will sum up and we'll go for question answer session.
All right, fine. Okay, well, let me take a minute on conclusions then. So I start by saying, what's the danger of any in lifting the veil too readily? All right, well, the answer to that has to be erosion of the fundamental principle of corporate personality. That's a fundamental principle. I mean, it's been said that it goes to the very heart of company law, right? And if we erode that too much, then that's going to lead to uncertainty, all right? Commercial uncertainty. Can we be certain that a company's legal personhood will be respected, all right? Will be regarded? If we're going to disregard it too often and too readily, then there is a danger of commercial uncertainty resulting. People are entitled to organise their commercial affairs on the basis of this fundamental principle. And if it's going to be departed from too much, then people are not going to know where they stand. And then I say that are the differences between the three jurisdictions that I've touched on, are they justified as a matter of legal principle? Well, arguably not, given that the principle of corporate personality is the same in all three jurisdictions. You got that principle from the UK just as we did here in New Zealand. So the starting principle is the same everywhere. So why or what justification could there be for the exceptions to that principle differing from one country to another? So I think perhaps in relation to the second question, can I refer you here to Lord Justice David Richards? This is in Rosendale Borough Council. This is a decision post-Prest, in other words, subsequent to Prest, 2019. And he says that, you know, the possibility of piercing a veil, the possibility of piercing a veil should be highly circumscribed is not surprising. All right, so it is highly, he's talking about the English position, isn't he? Highly circumscribed as it is. But here, look at this: registration of a company under the legislation creates a legal person with all that follows. That's my emphasis, with all that follows. Lots and lots of features of companies rely on the fact that the company is a legal person. Lots follows. As I said before, that principle goes to the heart of company law, as the House of Lords affirmed in Seamen. All right, and he's pointing out here that the acts, he's meaning by that the Companies Acts, they contain no provision for disregarding separate legal personality. There's no general provision in your statute or our statute or the UK statute that enables the court to disregard separate legal personality. And in fact, it's contrary to what your section 9 says. It's contrary to what our section 15 says. Our section 15 says a company is a legal person in its own right. And look at this word remarkable that he uses. It is therefore remarkable that by invocation of a common law power, the courts can nonetheless disregard a registered company's separate legal personality. So I think Lord Justice David Richards would want to answer my question here, that there is no justification as a matter of legal principle for the differences that we are seeing between the three jurisdictions that I have touched on. Professor Shinde, I probably took more than a minute.
Thank you, sir. Now let me, before going for question answer, let me just summarize the whole session for the benefit of the students. Sir started with the concept of corporate personality, and sir started with various questions, the fundamental questions regarding the company. The questions are like this. First of all, there is a statement: company is not an item of property. That itself is a statement as well as a question. Second is, why is a legal person, why that legal personality is required? Then what is a corporation? What is incorporation? Then what is a corporate veil? Who lifts the corporate veil? And when do we lift the corporate veil? The session was answering an attempt to answer these particular questions, and in order to do the same, sir referred to the three jurisdictions or three viewpoints. One is from New Zealand with the help of cases, and one is from UK and Indian position. And finally, sir gave his opinion regarding the UK and New Zealand position and the Indian position. And when it comes to the Indian position, we, like I said, that we have, our position is pretty much vague. And here the concept of lifting of the corporate veil is done on in order to protect the public interest, which itself is a very, very wide term. So in this lecture, apart from the information, there are many questions which are like food for thought, because we need to address these particular queries, that where we are heading ahead. If we keep on doing this thing, then there is very threat to the concept of corporate personality itself and to the section 9 of Indian Companies Act. Now, taking few queries, we have got a query from our faculty, Dr. Amit Kashyap, and the question is simple, like I'll just go directly to the question: whether arbitral tribunal can uplift the corporate veil. I'm just simplifying the question. Can arbitral tribunal lift the corporate veil?
Can a tribunal, was it? An arbitral?
Arbitral tribunal.
Well, I don't see why not. Doesn't such a tribunal apply law? So unless there was some terms of an arbitration agreement between the parties to the contrary, I would have thought the answer had to be yes, on the basis that arbitration is simply an arbitrator attempting to apply the law rather than a court.
Okay. So there is one more query. Now, whether the concept of corporate personality, whether it is applicable only to the registered corporations or it can be extended to the partnership firms? Like, what is the position in New Zealand?
Well, in New Zealand, an ordinary partnership, as we refer to it, is not a legal person. So therefore, there is no question of ignoring the legal personhood of a partnership. All right, we talk about a firm, but the firm has no recognition as a legal entity. So we do have a Limited Partnerships Act in New Zealand, under which there is an incorporation process, and the so-called limited partnership is in fact a legal person, all right, because the statute says so. But that's a very particular kind of partnership. It's not the ordinary or conventional notion of a partnership. So when it comes to ordinary partners, there's no veil to lift. All right. In New Zealand, as I'm sure it's the case in your country, all right, the ordinary partnership is not recognised as a legal person. The partners are not. The partnership is just a collection of the partners. So in terms of our limited partnership, which is a legal person by reason of registration or incorporation under the Limited Partnerships Act, then it would be possible, because it would be possible for the veil of that entity to be lifted.
Thank you, sir. So now, due to paucity of time, we'll not take further questions. Now I call upon our student Jasprit Singh Gulati to present vote of thanks. Jasprit.
Thank you, sir. I convey my regard to the honorable guest speaker, respected director, madam, teachers, and my dear friends. I, Jasprit Singh Gulati of Institute of Law, Nirma University, would like to thank our guest speaker, Professor Lindsay Trotman, who graced us with his presence and guidance. Thank you, sir, for sharing with us your words of wisdom. We did learn a lot. We have been fortunate to be assisted by our director, Dean Madam, for constant support and encouragement. Thank you, ma'am. I thank Shreya ma'am and Anand sir for helping in organizing this insightful session. I extend gratitude to the non-teaching staff and to the students for showing interest and actively participating in this session. Thank you all and have a nice day.
Thank you very much. It's very kind of you.
Thank you, sir. Shreya ma'am.
Thank you, sir. Thank you, Professor Trotman.
My pleasure. My pleasure. My pleasure. So
we hope next year we will be there in campus, sir.
Oh, that would be wonderful. That would be wonderful.
Thank you, sir. Thank you very much.
All right.
Thank you all.
I shall leave the meeting.
Okay,
bye for now.